Good day everyone, especially to you, ma'am. I'm Criscia Autentico, and today I'm going to discuss to you the Chapter 5 of Philippine Tourism Laws, which is the Law on Sales, Agency, and Credit Transactions. But before that, let me read you this. Agents should ideally work for the best interest of the client because of the trust given them. Agents initiate, administer, and collect on behalf of the client. By Elizabeth Winthrop. And now let me introduce you to our topic outline. First is the laws on sales. Second, characteristics of the contract of sale. 3 is requisites of the contract of sale. Fourth is effect of loss of the object in the contract of sale. 5 is sale of personal property payable installments. 6 is pacto de retro sale or conventional redemption. 7 is obligations of the vendor. 8 is obligations of the vendee. 9 is liability of principal and the agent. 10 is simple loan or mutum. And lastly, 11, the pactum promissory. And by the end of this chapter, we intend to describe and explain the nature of sales transactions. Second is identify functions and operation of agencies in the industry. And lastly, identify ways of handling credit transactions. And now let's proceed to our first topic, which is the law on sales. In tourism, travel, and hospitality industry, agreements arising from contracts will have to be made, and potential branch of from these agreements will be encountered. A contract of sale is one of the usual contracts being encountered by the industry concerned. This will give you an overview of the different sales transactions which may be encountered, including the remedies of the parties concerned. The law, Article 1458, by the contract of sale, one of the contracting parties obligates himself to transfer ownership of and to deliver determined things, and other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. The characteristic of the contract of sale. First is the commensual. A contract of sale is perfected by mere consent. No form is prescribed for the perfection in a contract of sale except in the following instances. A. Those covered under the statutes of frauds, which must appear in writing, otherwise the sale is considered unenforceable. For example, a sale of real property or any interest therein, and the sale of chattels or good for a piece not less than 500. B. Sale of real property made to an agent, in which case the agent's authority must be in writing, otherwise the agency and sale made through an agent is void. Number 2 is the bilateral, because it gives rise to reciprocal obligations. 3 is the principal, because it can stand by itself without need of other contract. 4 is usurious, because the consideration for each party is the delivery of the thing or the payment of the price. Fifth is the commutator, because what the vendor or the seller delivers is considered equivalent of the price paid by the vendee or the buyer. 6 is nominate, because it has a designated name under the Civil Code of the Philippines, which is sale. 7 is transmissive of the courtship, because the vendor transfers ownership of the subject matter to the vendee. And now let's proceed to the effect of loss of the object in the contract of sale. The law, Article 1480, any injury to or benefit from the thing sold after the contract has been perfected, from the moment of the perfection of the contract to the time of delivery, shall be governed by the Article ZZZ 1262. Article 1262, an obligation which consists of the delivery of the terminated thing shall be extinguished if it should be lost or destroyed without the fault of the debitor, and before he has incurred in the Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him and in a manner of the ways specified in Article 1497 to 1501, or any other manner signifying an agreement that the possession is transferred from the vendor to the vendor. If the thing is lost before perfection of the contract is considered inexistent before the loss of the bond by the seller based on the principle of the owner of the thing who bears the consequences of the loss. If the thing is lost at the time of the perfection of the contract shall be considered without any effect. The legal effect is the same as the object is lost before perfection of the contract of sale. If the thing is lost after delivery, the buyer bears the risk of loss since delivery transfers. If the thing is lost after perfection but before delivery, the seller bears the risk of loss since there is no delivery yet, hence no transfer of ownership to the buyer. This is considered just and equitable, being more in conformity with the principle of the principle of first period domino. In this case, the buyer may demand the return of the prior, in case payment has been made. The reciprocal nature of the contract of sale dictates that when there is an obligation to deliver a determinate object, there is also an correlative obligation to pay the price. Therefore, once the obligation to deliver is perpetuous event or even without it is also extinguished. This rule will apply. Therefore, this rule will apply even if the thing is lost through a price default of the debutant. And now let's proceed to the sale of personal property payable in installments. It is possible that in buying personal properties used for public transportation or delivery of goods, for example, buses, cruise ships, and delivery trucks, this provision will be useful for the contracting parties in case of sale of personal properties payable in installments. The Article 1484, in a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. First is exact fulfillment of the obligation should the vendor fail to pay. 2 is cancel the sale should the vendor's failure to pay cover 2 or more installments. 3 is foreclose the chattel mortgage on the thing sold if one has been constituted. Should the vendee failure to pay cover 2 or more installments, in this case, he shall have further action against the purchaser to recover an unpaid balance of the price. Any agreement to the contrary shall be void. 1544, if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession in the good faith. It should be movable property. It is should immovable property. Ownership shall be belong to person acquiring it who in good faith first recorded it in the registry of property. There should be no inscription. The ownership shall pertain to the person who in good way was first in the possession, and the absence, therefore, to the person who presents the last or the oldest title, provided there is a good faith. The provision pertains to the same property which has been sold to different buyers or vendees. In case as immovable property covered under the torrent's title, it's sold to different vendees. The one who is the first registrant in good faith at the registry of deeds, where the property is located shall be perfect. Now let's proceed to another topic, which is the pacto de retro sale or the conventional redemption. The law Article 1601, conventional redemption shall take place to Vendor reserves the right to repurchase the thing sold, with the obligation to comply with the provision of Article 1616 and other stipulations which may have been agreed upon. In 150, the discussion of the law as between an absolute sale and a sale with right to repurchase, no difference exists, except that in the latter the ownership of the purchaser is object to resolutory condition that the vendor exercises his right to repurchase within the time agreed upon. The vendor or retro has no right over the thing pending the redemption. He may, however, register the property in his name with an express statement of the purchaser's right. The vendee, a retro immediately acquires title and possession of the property sold, subject only to the vendor's right of redemption. The vendee who acquires the ownership of the property may dispose the same as any of other being may therefore tolerate make dispositions mortis causa or inter mortis. Vendee and retro immediately acquires title and possession of the property sold, subject only the vendor's rights of redemption. The vendee who acquires the ownership of the property may dispose of the same as any other owner. He may therefore mortgage. And now let's proceed to the next topic, which is the obligation of the vendor. The Article 1495, the vendor is bound to transfer ownership of the deliverer as well as warrant the thing which is the object of the sale. Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him. Article 1497, the thing sold shall be understood as delivered when it is placed in the control and possession of the vendees. Under the provisions, the obligations of the vendors are 1. To deliver the thing, 2. is to transfer the ownership of the thing, and 3. is to warrant against eviction and against hidden defects. Delivery is not only a necessary condition for the enjoyment of the thing, but is a mode of acquiring dominion and determines the transmission of the ownership, the birth of the real right. The fact that the price of the property delivered has not yet been paid in full is not an obstacle to the acquisition of the ownership thereof by the vendee if such condition has not been stipulated in the contract. When goods are delivered to the buyer on a sale or return, to given the buyer an option to return the goods. Instead of paying the price, the ownership passes to the buyer on delivery, but he may revest the ownership in the seller by returning or tendering the goods within the time fixed in the contract, or if no time has been fixed, within the reasonable time. When goods are delivered to the buyer on approval or on trial or other similar terms, the ownership passes to the buyer. First, when he signifies his approval or acceptance to the seller or does any other act adopting the transaction. Second, if he does not signify his approval or acceptance to the seller but retains the good without giving notice or rejection on expiration of the time as fixed for the return of the goods, or on the expiration of the reasonable time when no time has been fixed. And a warranty in case of eviction. A warranty is a case of eviction in an simplified warranty is contracts of the sale, by virtue of which is the vendee is deprived of the whole or part of the thing purchased by final judgment based on the right prior to the sale or an act imputable to the vendor. Such vendor shall answer for the eviction even though nothing has been said in the contract on the subject. The requisites of evictions are 1. Vendee is deprived of the thing purchased or partially. Second, the deprivation is final judgment. Third is deprivation is based on the right prior to the sale of an act imputable to the vendor. Lastly, the vendor was summoned in the suit of eviction at the instance of the vendee. Liability of the eviction includes: first, return of the value at the time of the eviction; second, return of income or fruits that the buyer had to surrender. Third, cost of suit. Fourth is expenses of the contract. And lastly, 5, damages in the case the vendor acted in bad faith. And now let's proceed to the obligations of the vendee. The law, Article 1582, the vendor is bound to accept delivery and pay the price of the thing sold at the time and place stipulated in the contract. Discussion of the law is action for breach of contract of sale. Extrajudicial remedies. First, of the buyer. A. The buyer need not pay unless there is delivery. B. The buyer may reject improper delivery. The buyer may suspend payment if he is or of the thing or has reasonable grounds disturbed in the possession of or ownership to fear such disturbance. 2. Of the seller. A. Vendor is not bound to deliver the thing sold if the vendee has not paid the price. B. Is installment sale or direct to unmissed law. Judicial remedies of the buyer. A. Damage for breach of contract. Of the seller is A. Recovery of the price. B. Is damages in case of bad faith. The law, Article 1868, by the contract of agency, a person bends himself to render some service, to do something in representation or on behalf of other or another with the consent or authority of the latter. 1709. A contract of agency is a relation in which one person, the agent, acts on behalf of another, the authority of the latter, the principal. It is fiduciary relation which results from the manifestation of consent by one person that another shall act on the former's behalf and subject to his control, with consent by the others to do acts. The acts of the agent will be binding on his principal. The essential elements of the agencies are: first, there is consent expressed or implied. 2. The object is the execution of judicial act in relation to third person. Third is the agent acts as a representative and not for himself. Fourth is the agent acts within the scope of his authority. And now let's proceed to our next topic, which is the liability of the principal and the agent. Law, Article 1883, if an agent acts in his own name, the principal has no right of action against the person with whom the agent has contracted, neither have such person against the principal. In such case, the agent is directly bound in favor of the person with whom he has contracted, as if the transaction were his own, except when the contract involved things belonging to the principal. And now let's proceed to our next topic, which is the simple loan or motum. The law, Article 1956, no interest shall be due unless it has been expressly stipulated in writing. In a contract of loan, if a particular rate of the interest has been expressly stipulated by the parties, such stipulated interest shall be applied. If the exact rate of the interest is not mentioned by the legal rate, shall be payable. It is only in contracts of loan with or without security that interest may be stipulated and demanded. The debitor in delay is also liable to pay legal interest by way of indemnity for damages, which legal interest may be agreed upon, and in the absence of any stipulation, the legal interest shall be in 12% per annum. In all cases, interest due shall earn legal interest from the time it is judicially demanded, although the obligation may be silent upon this point. In the nature of bank deposits, it is clear from Article 1980 of the Civil Code of the Philippines that fixed, savings, and current deposits of money in banks and similar institutions shall be governed with the provision of Civil Code concerning simple loan. Hence, a debitor-creditor relationship exists between a bank and a depositor. This is why compensation may take place where a bank may validly debit to the account of its depositor or depositors who are indebted to the bank by way of loan. Now let's proceed to our next topic, which is the Pactum Mimosorium. The law Article 2088, the creditor cannot appropriate the things given by the way of the pledge of the mortgage or dispose of them. Any stipulation to the contrary is null and void in 1859. The Pactum Commissarium is defined as a stipulation giving power to the creditor to automatically appropriate the thing given as security if the principal obligation is not fulfilled without any formality, such as foreclosure proceeding and public sale. And that's it for my report. I hope you learned something. And again, I'm Criscia Autentico. Thank you for listening.